Judgment in the matter of the Queen on the application of Jalloh versus Secretary of State for the Home Department.
The common law has for centuries protected the right to physical liberty, the right not to be imprisoned without lawful authority, whether by the state or by private individuals. That is why we have the remedy of habeas corpus to procure the release of someone who is unlawfully imprisoned. That is why we have the tort of false imprisonment, whereby someone who has been unlawfully imprisoned can claim damages from the person who has unlawfully imprisoned him. This case is about what is meant by imprisonment at common law, and whether that concept should now be brought into line with the much more recent concept of deprivation of liberty under Article 5 of the European Convention on Human Rights. The claimant, who claims to be a Liberian national named Ibrahima Jalloh, although his identity is disputed by the Home Office, was released from immigration detention on bail in October 2013. On the following day, he reported to an immigration officer. He was given a document headed Notice of Restriction, purporting to impose restrictions on him under a particular provision in the Immigration Act 1971. The restrictions included a requirement to report to an immigration officer every Monday, Wednesday, and Friday, to live at a specified address in Sunderland, to submit to electronic tagging, and to stay at home each night between the hours of 11 p.m. and 7 a.m. The notice warned him that he would be liable to imprisonment or a fine if he failed to comply with the curfew without reasonable excuse. Electronic monitoring equipment was installed, and the curfew was in place from the 3rd of February 2014 until the 14th of July 2016, a total of 891 days. On the whole, the claimant complied with the curfew, although he did break it on a number of occasions, leaving the house, among other things, for religious observance and to attend family court proceedings in Coventry for some or all of the curfew time. In 2016, it was held by the Court of Appeal in another case that the Secretary of State had no legal power to impose restrictions by way of curfew in this way. As a result, the High Court ordered the claimant's curfew to be lifted. The Secretary of State now accepts that the curfew was unlawful from the start. The claimant therefore sought damages for false imprisonment. The trial judge held that he had been falsely imprisoned and awarded him damages of £4,000. The Court of Appeal upheld that decision. The Home Secretary now appeals to this court. The Home Secretary argues, first, that this was not imprisonment, because the claimant was not physically prevented from breaching the curfew, and did in fact do so from time to time. The Supreme Court unanimously rejects that argument. The essence of imprisonment is being made to stay in a particular place by another person. The methods which might be used to keep a person there are many and various. They include physical barriers, guards, or threats of force or of legal process. In this case, the Home Secretary defined the place where the claimant was to stay between the hours of 11 p.m. and 7 a.m. There was no suggestion that he could go somewhere else during those hours without the Home Secretary's permission. Although he broke his curfew from time to time, this made no difference to his situation while he was obeying it. Like a prisoner who goes absent from an open prison, or a tunneler who successfully escapes from a German prisoner of war camp, he was not imprisoned while he was away, but he was imprisoned as long as he stayed at home. Although it was physically possible for the claimant to leave, his compliance was enforced and not voluntary. He was wearing an electronic tag, which meant that leaving his address would be detected. The monitoring company would then telephone him to find out where he was. He was warned in the clearest possible terms that breaking the curfew could lead to a £5,000 fine or imprisonment for up to 6 months, or both. He was well aware that it could also lead to his being detained once more under the 1971 Act. All of this was backed up by the full authority of the state, which was claiming to have the power to do this. This is a classic case of detention or confinement. The Home Secretary argues, secondly, that such a curfew does not amount to a deprivation of liberty for the purpose of the right to liberty protected by Article 5 of the European Convention. The concept of imprisonment at common law, it is argued, should therefore be brought into line with the concept of deprivation of liberty. The Supreme Court unanimously declines to do so. Although the common law may develop to meet the changing needs of society, this proposal would not develop the law, but make it take a retrograde step. It would restrict the classic understanding of imprisonment at common law to the very different and much more nuanced concept of deprivation of liberty under the European Convention. This approach derives from the need under the Convention to distinguish between the deprivation and the restriction of physical liberty. There is no need for the common law to draw such a distinction, and every reason for the common law to continue to protect those whom it has protected for centuries against unlawful imprisonment, whether by the state or by private persons. The Supreme Court therefore unanimously dismisses this appeal. The Court will now adjourn.